The Supreme Court is set to rule in a case which will be huge for the Second Amendment movement and litigation going forward. So let's talk about what is happening. But real quick before we jump into this video, I want to thank one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee and they're huge Second Amendment supporters. They have dedicated roasts for organizations like FBC, GOA, and SAF. So if you want to get amazing coffee, support the 2A cause, check them out using the links down below. And if you use the code ARMSCHOLAR, you can get 10% off of your order. As I mentioned in the intro, in this video, we're going to be discussing an important case, which is huge for the Second Amendment movement and was recently heard by the Supreme Court. Now, although these cases are not 2A lawsuits, they still are going to be significant for what we need to do for the 2A movement and current litigation that we have going on. These cases can help stop the ATF's pistol brace rule, their ATF bump stock ban, the frames and receivers rule, their attack on FRTs, and other types of state cases that are going on right now, like restrictions on rifles, magazines, and other things that states put in place. The case we're going to be talking about in this video is called American Forest and Paper Association versus the EPA. These cases aim to stop current EPA overreach and regulation on air emissions. You might be thinking to yourself, okay, air emissions, how does this help us with the 2A cause and 2A litigation? Now, what is very important for the Second Amendment movement is the procedural posture of these cases and how it is now set to be decided by the United States Supreme Court. In this case, a group of states, companies, and trade associations are seeking to temporarily block a rule issued by the Environmental Protection Agency, essentially to reduce air pollution from power plants and other industrial facilities in 23 states. These 23 states do not want to adjust their air emission policies, and so they're fighting back against the EPA and the procedures and rules that they put in place. The law at center in this case is known as the Good Neighbor provision of the Clean Air Act. It requires upwind states to reduce air emissions that affect the air quality of those downwind states. And this all revolves around a 2015 order by the EPA where they issued a new air quality standard. The new EPA standard triggered an obligation for states to submit plans to the EPA to indicate both how they would comply with those standards that the EPA came up with and how they would reduce the emissions in their states and how they would try to help those individual states that are maybe downwind from them. The dispute in this case arises from the EPA's decision to essentially reject plans that were submitted by 21 states. These 21 states submitted their plans to the EPA, but those plans included absolutely no proposed changes to those state emissions. So the state said, no, we're not going to adjust our emissions. The EPA responded by throwing out those proposed state plans, and a month later, they came up with their own plan, published their own plan for those states. So the EPA came up with their own emission plans that they wanted to enforce on those 21 states. Now, of course, the states did not take kindly to the EPA telling them what they had to do, especially since many of those states did not want to adjust their rules and their emissions at all. Now, the plan that the EPA came up with was set to take effect last August, but in response, 3 states, which included Ohio, Indiana, and Virginia, went to the United States Court of Appeals in DC and sued the EPA. The states challenged the proposed plan along with several companies who also joined them in the lawsuit and, sued the EPA. Now on review, a divided DC Circuit Court panel denied the plaintiff's request for a temporary block of that EPA plan. Now in response to losing the preliminary injunction at the lower court level, the states filed an emergency application to the United States Supreme Court. The emergency application asked for the Supreme Court to step in early and grant a stay on that lower court decision. Now, last December, the Supreme Court granted the emergency application review and then also fast-tracked the case for oral arguments, which took place in February. Now, during the oral arguments, the court's conservative justices voiced skepticism about the process that the EPA allowed, that they followed here and tried to implement with this rule. Now, in contrast to the conservatives who were very anti-EPA, the liberal justices were very concerned about the procedural posture of this case and what this means going forward for other lawsuits. The liberal justices on the court were very concerned about stepping in early and putting the rule on hold before any lower court has had a chance to weigh in on the merits of the issue. The liberal justices were very concerned about what they believe was an unusual procedural posture in this case and how it came to the court. The justices believed that if the court here were to put the EPA's federal plan on hold in this case, it would open the door for other lawsuits and other types of issues to now make their way up the Supreme Court on an emergency basis, and the Supreme Court would have to review those emergency applications. And that's where this becomes very relevant for the Second Amendment cause and various litigations that are going on right now against other organizations and other, executive agencies like the ATF and other state governments, for their restrictions on the Second Amendment and trying to challenge this overreach. Way too often in the Second Amendment cases in our 2A cause, we have to kind of slog through years of litigation. Oftentimes, even though we get wins in the lower courts, or even when a rule like the pistol brace rule is found clearly invalid and struck down, we have to then wait years and years for lower courts and Circuit Court of Appeals to take action in these cases. Sometimes in these cases, you will also see lawsuits that actually go up to the United States Supreme Court seeking emergency applications, emergency stays from the Supreme Court. And in these emergency applications, oftentimes you see the Supreme Court say, well, it's too early for our intervention. It's too early to get involved in these litigations, to rule without a merits decision when it comes to Second Amendment rights. And therefore, we're not going to rule early or we're not going to intervene early. In fact, right now we have multiple cases up in the Supreme Court asking for Supreme Court early intervention, emergency applications. A bunch of these right now are coming out of Illinois with the rifle magazine ban issue. However, all too often you hear me and other people tell you guys that, it's a long shot because the Supreme Court's practice in their current precedent is that they do not want to get involved early in these cases and that they will not issue stays or early intervention in these cases. Well, these lawsuits here can open the door and provide new precedent to get the Supreme Court to intervene early in these cases. The new precedent will be that the Supreme Court has issued a recent stay when it came to EPA cases, and therefore they should do the same when it comes to government overreach, maybe when it deals with the ATF or other states who are infringing on 2A rights. And the liberal justices in this case were very concerned and very aware of the potential of what could happen if they rule against the EPA. Justice Jackson stated in her opinion that it's fairly extraordinary to be asking the court to decide this matter when you haven't even briefed, much less lost, the case in the DC Circuit Court yet. Pointing to the compliance deadline of 2026, she also stated that, so I'm trying to understand what the emergency is that warrants Supreme Court intervention at this point. And she suggested that in cases like this, the Supreme Court should require applicants like the challengers to show extraordinary harm before putting a federal rule on hold. She also pointed to the fact that she was very concerned and a little concerned about what was really being argued here and what she believed it was being boiled down to is that the people here, the states here, believe that they have a meritorious claim and that they don't want to follow the law and they don't want to go through all the procedural challenges, and therefore they want early intervention from the Supreme Court. So that's what Justice Jackson was kind of boiling that down to. And then she said that I don't understand why every single person who is challenging a rule doesn't have the same set of circumstances. And so again, she was signaling that this would open the door for other cases. Now, Justice Sotomayor was also very concerned about this issue. She voiced her concerns, and she stated that it was an inversion of the normal rules for challengers to try to bypass the very court who was going to make a substantive decision or a merits decision on this issue. And then Justice Kagan, the last liberal justice, was also very concerned about what would happen in future cases if the Supreme Court granted the emergency stay request in this case. She stated that the idea that you can be here and demanding emergency relief just because states have kicked up a lot of dust seems not the right answer to me. Now, in contrast to the 3 liberal justices, the 6 conservative judges did not seem concerned at all about granting the emergency stay and what that would mean procedurally going forward for other cases. So why is this EPA emissions issue in this case so important for 2A lawsuits going forward? First, the lawsuit and arguments signal that the Supreme Court, of course, is very much done with agency overreach and agencies like the EPA just doing these flippant decisions on their own. But even more important, what this does is it opens the door procedurally going forward for all these 2A cases. The hope is that we will be able to combat any offhand arguments going forward, that in the past have been simply put forward that Supreme Court doesn't do this type of thing. We can respond by saying, well, that's funny because they just did that in the EPA case in 2024, and they should do the same thing here in these 2A cases. So like I said, although this case did not deal directly with 2A issues, it still has huge implications going forward for the 2A cause. Way too often we hit procedural roadblocks, and this decision here can help remove those roadblocks. Now we're going to wait to see what the decision is of the Supreme Court, but listening to the oral arguments, I think this will probably be a 6-3 decision against the EPA. It's going to be interesting to see what the language is as far as procedure. I wonder if some of these liberal justices are going to write dissent about the procedural posture of this case, that the Supreme Court shouldn't have stepped in early. Again, this is still on the shadow docket. It's an emergency application for a stay. But again, that's all very relevant for what happens often in 2A cases. A lot of emergency applications have gone up to Supreme Court on an emergency basis, seeking stays, and all too often the Supreme Court has rejected those. This case can finally help us to get that type of relief. So when we get the decision and when we get additional information, I will let you guys know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.